Okay, so we're going to get started. My name is Kyle Herbert, Herbert Law Firm. We put these on the first Friday of every month on a variety of topics. A lot of them have to do with personal injury trial law, which is what I do, but a fair amount are just kind of random and interesting stuff. For example, a couple months ago, we had Romo's office here to talk about the Sandy Hook trial against Alex Jones. And so we will try and send you email updates just to let you know what the next few topics will be. November is not set yet. But I think in December, we're going to have an attorney who practices in North Carolina, who was the former chief information officer for George Bush's White House. And he's going to come and give us a brief discussion about his thoughts on the Mar-a-Lago documents and how the president's transition team is supposed to work with the National Archives. So that has nothing to do with personal injury trial law, but I think will be an awesome topic. So stay tuned for that. Our speaker today is Jared Johnson. He and I are actually both going to talk about this same topic a little bit. I've worked with Jared many times over the years. When I resolve a personal injury case and I got to go pull up the hospital lien file and try and get it resolved, I'm usually delighted to see Jared's name. He is an attorney. He has what I believe are great ethics and morals when it comes to trying to get these things resolved, looks out for his client, but also understands the reality of a PI practice. And I think that endures both to our benefit as lawyers and to his clients who get claims resolved pretty quickly. Lots of times in my practice, I end up dealing with some random billing company that half the time isn't even located in the state of Texas. And they've got a silly rubric, and I'll call them and try and get a case done, and they will read off a script, and then I'll throw the phone at his door. So Jared he lives in Waco, practices part-time in Houston. The firm is Sullins, Johnson, Rohrbach, and Majors. And this is all he does is lien filings and lien reductions for some of the biggest hospital systems in the state. I think he's one of maybe 2 or 3 people in the state of Texas that are really experts on this topic, and we are delighted to have him. We have a bunch of people watching, not outside those windows. Outside the concert. If you guys can't hear us, we have made efforts to make our microphone system work a little bit easier. But if you can't hear us well or have a question, you can chime in by typing in the message room, and our staff in the back will wave me down so we can fix whatever technical issues we have, but I'm getting a lot of thumbs up now. So without further ado, we're going to jump right into a scintillating talk about the ever sexy topic of hospital liens in the state of Texas. So me and Jared put this slideshow together. The first slide says, that's the beautiful thing about hospital liens. They can be anything we want them to be. Dr. Leo Spaceman from The Office, not The Office, from 30 Rock. So I started with this slide to kind of, to a certain extent, these hospital liens, from my perspective, are kind of a shell game, right? As a plaintiff's lawyer, I want those damages to be as high as they can possibly be to get the greatest recovery for my client. And then when the case settles, I have to go to these providers and lien holders and explain, oh, come on, those bills shouldn't have been that high. My client wasn't even hurt. He was barely bleeding from the head, and his arm reattached. And so as a plaintiff's lawyer, I kind of got to massage these numbers to get the best recovery for my client, which is what the law requires me to do. At the same time, the appellate courts and the Texas Supreme Court have struggled mightily over this issue of what is a reasonable and necessary charge that a hospital ER can charge you after a car accident. And so to that extent, it's also kind of, it can be whatever you want to be, because it seems as though what the Texas Supreme Court says, what it lacks in specificity, it makes it for an ambiguity sometimes. And I think that might in fact be by design. Go ahead.
Yeah, no, I mean, you're right that what is a reasonable charge is an open question in Texas law and most of the country these days.
And we're going to get kind of more into what some of those factors are. But let's go ahead to the next slide. So it all starts with Texas Property Code, Chapter 55. Jared, what does Chapter 55 tell us about hospital?
The most important thing for you to know is that hospital liens arise automatically once a accident victim is admitted to the hospital within 72 hours of the accident. They don't have to go straight from the accident scene to the hospital, but they have to go to a hospital and receive treatment at that hospital within 72 hours of the accident. And then the hospital lien arises into existence.
So two of the litigated issues on this are, what is treatment?
Receiving any service in any department in the hospital. Some argue that the triage nurse taking your temperature and asking you what's wrong with you is treatment. I don't like those cases where the injured individual just sits in the emergency room, waiting room for 3 hours and then leaves. But some hospitals have argued that that was admission to the hospital. And I can't say for certain that they're wrong.
So I get injured in a car accident, I walk in, wait for 3 hours, get a diagnosis, take some Advil, go home, that's treatment.
Yes, if you got that diagnosis after getting out of the waiting room and going back to a treatment room, yes, that's admission.
Okay. I injure myself in a one-car accident where I wrap it around a telephone pole. Can you guys file a hospital lien over my accident involving just me?
Probably not, unless some farmer's stray cow is the reason you drove into that hospital, into that tree. Probably not. There has to be the negligence or fault of another party that caused your accident for the lien to attach to anything. A hospital can file a lien thinking that you have a claim, but if you have no claim, unless you're going to sue the tree, there's nothing for the lien to attach to, so it's worthless.
So innocent tree, innocent telephone pole, you guys are stuck.
Right, the lien, there's no hospital lien in that case.
What if I break my toe in a car accident, I tough it out for 4 days, then I show up?
That you haven't been admitted within 72 hours, so the lien still doesn't arise.
All right. Anybody breaks a toe, just good at that for the first 2 minutes. Okay, next slide. Tell us what goes into a valid lien.
Okay, so for the lien to be perfected, you must file a written notice with the county clerk in the county where the hospital is located. And the lien has to contain the name and address of the injured individual, the name and location of the hospital claiming the lien, the date of the accident, and the name of the liable party or parties, if known, to the hospital at the time of the filing.
So two issues I see with these. The first one is lots of folks don't know where to look for liens because they don't know where they're supposed to be filed. But they're supposed to be filed
In the county where the hospital is located.
That hasn't always been the law.
No, long ago, it was the county where the accident happened. But that was too hard for people to know where to look. So they decided, well, the hospital's not moving around, so let's file it in the county where the hospital is located.
So in my office, we check both the county where the accident happened and the county where the hospital is located. Sometimes we'll check the county of where the defendant lives, where the plaintiff lives, just in case, because folks that do your job don't always do it as well as you do. Steph, the other issue I wanted to talk to you about is I have never seen a lien filed with the name of the third party tortfeasor, and it's never happened. Do you know why that is, and if there's any magic to that?
Well, usually the lien holder is filing the lien as soon as they can, which is usually shortly after the treatment at the hospital. And so they honestly just don't know who the liable party is. But you may have some facts in a certain case where the hospital found out about your lawsuit before they filed the lien. in that case, the hospital is obligated to put the name of your defendant or defendants on the lien instrument when they file it, or arguably the lien is invalid.
So I gave you a hypothetical earlier. I said, what if I'm in a car accident and both injured parties show up at the same hospital, same intake desk? You think I've got an argument to say you knew who the defendant was because we walked in at the same time with the same set of cops?
Well, sure, you have an argument, but I don't think that's a winning argument.
You're literally reciting what every judge says to it. It's an argument.
I can see like Judge Garrison saying that too.
Yeah.
Yeah. I don't think you'll be able to pin the knowledge of the liable party on the nurse or the X-ray technician. Just, you know, to say, well, they knew that my buddy who was the driver who ran into the tree was liable. I think that's a stretch.
So you put all the right stuff in your lien, maybe, and then you guys file it, not within 5 days of the treatment, but within 5 days of.
Within 5 days of receiving notice from the county clerk that your lien has been recorded, you must send a letter to the injured individual stating that you filed a lien. It attaches to their claim or cause of action arising from the accident, and that it does not attach to real property.
Okay, but do you really have to send the letter?
You absolutely have to send the letter.
All right, next slide. Doesn't matter if you never get the lien in the mail, so long as they send it. The statute says, so long as the hospitals and Jared substantially comply, just do their very best. That's good enough. The lien's going to attach. So
now there is a case where the hospital missed the accident date by a day and named the patient as the liable party. And the Court of Appeals up in Fort Worth said that that lien was unenforceable because they'd gotten the accident date wrong. And that's all, the whole thing was just that the accident date was wrong, but they chastised them for, if the patient had really been responsible for the accident, then the lien wouldn't exist in the first place because it has to be the fault of another person. But you know, I don't think that's good law. I'm perhaps looking for the right case to challenge that law, but it's out there that says you missed the accident date by a day and the lien is unenforceable, and the hospital was arguing we substantially complied with the statute, and the Court of Appeals up in Fort Worth said you gotta get it right.
but for practitioners, the basic idea is, yeah, go ahead.
Sorry, there is a question on the chat.
Yeah.
Are you allowed to file a lien if the patient provides you their insurance information at the time of treatment?
Yes, you are. Unless you're filing an EMS lien or a physician's lien, which also comes out of Chapter 55 of the Property Code. EMS providers and physicians don't get a hospital lien or a physician's lien or an EMS lien if the patient has private health insurance. They can still possibly get it if they've got Medicaid or Medicare. But there's no such similar restriction for hospitals. So you can file a lien anticipating that the private health insurance isn't going to pay you your full contract rate or the full amount that you're entitled to collect.
But the bottom line is the statute is intended to have enforceable liens. And so most courts, they're going to give you a little bit of leeway. They're going to only require substantial compliance.
Most courts, considering hospital lien disputes, start their opinion by restating that the purpose of the hospital lien statute is to provide hospitals another way of getting paid for treating accident victims. And essentially, courts are going to bend over backwards to try to effectuate that purpose of the statute.
Okay. Next slide, please. So tell us what you did with the hospital lien.
You get a priority claim against the settlement or judgment of the cause of action arising out of the accident.
How big is your interest?
It is the amount of your charges, presuming that they're reasonable and regular, or 50% of the settlement or judgment. If there's actually a judgment and you try the case and the trier of fact expressly determines the amount of the hospital lien, it's the amount decided by the trier of fact less the hospital's equitable share of your attorney's fees for trying the case and getting that determination from the trier of fact. It's never happened. That's new as of 2019. I haven't had it come up yet, but
So I could
it's
theoretically,
out there.
stick St. Luke's or Moyle Herman with my medical, or with my attorneys.
If you ask the jury to determine the amount of the hospital bill or the amount of the hospital lien, then yeah, they have to pay a share of your attorney's fees.
I would love to have that. So this has come up. One of the issues is if somebody settles their case without including you guys on the release or providing some documentation that you agreed to it, that settlement is.
It's not good. It's null. That comes out of the statute, but it most famously came out of a Stowers doctrine case called Bleecker, where ironically a law clerk had the idea that, hey, wait, if there was a hospital lien out there, then the release isn't valid, and therefore the Stowers demand that they sent us that didn't say anything about addressing the liens wasn't good. And so we only have to pay our $100,000 instead of, like, I think it was $4 million that the insurance company thought they were on the hook for blowing Stowers. So it wasn't a hospital lien case, but the hospital lien and the demand not addressing the hospital liens carried the day.
So in my practice, I've never seen this in the context you might have of a plaintiff's lawyer stiffing a hospital. I have seen this in the context of some insurance companies swooping in, settling a case while the client is still under anesthesia and saying, you know, we're going to pay you up to $5,000 in medical bills and an extra $1,000 for your trouble. Oh, by the way, there's $100,000 medical. And I think we've actually discussed that before. That lien is that kind of a release valid?
If the lien was filed before, definitely before the patient signed the release, possibly before they cashed the settlement check. No, the statute says that release is invalid and you can still help them out when they regain consciousness and come to their senses.
So a lien procured that does not, a settlement procured in the face of a lien that does not account for the lien is revoked.
So long as the lien was perfected before the settlement, yes. Cool.
Okay, next slide. What does the lien not give you?
It doesn't give you a lien against wrongful death recovery, probably UIM or PIP or MedPay, first party auto insurance coverage, or homeowners MedPay, guest medical. It doesn't give you a lien against workers' compensation recovery if it's compensable injury. Doesn't give you a lien against the longshore and harbor workers recovery, but it does against the Jones Act case. Not sure why there's those are distinguished. If your client got treated in a hospital operated by a railroad, the lien doesn't apply in that case. But most of your cases, the hospital lien probably attaches.
It does not give you a right to recover costs or fees on behalf of the hospital from forcing the lien unless you guys later plead it as a debt caption or something weird. Is that right?
Yeah, that's probably true. The case law says you don't get interest and attorney's fees just for collecting a vanilla, run-of-the-mill hospital lien.
Right?
You mentioned it doesn't attach to a wrongful death claim. Do you know if it attaches to the survival claim?
Yes.
To the estate?
Yes, it certainly attaches to the survival claim. And I've had cases where poor pleading got the lien against the survival claim after the plaintiff said, oh, well, we'll abandon the survival claim and just get the wrongful death money that your lien doesn't attach to. And that was a problem. You know, if
I
you,
think in that case, they actually tried to replead it. But the appellate court said the essence of your pleading is what you did discovery on and what you argued before trial, just because you kicked the claim before it went to the jury.
yeah, if you've got a $30,000 policy and a $12,000 emergency room bill because the poor guy was pretty deceased before he got there, and 3 minor kids making wrongful death claims, don't assert the survival claim. You don't need it. It pales in comparison to the kids' wrongful death claims anyway. You know, since your survival claim is just conscious pain and suffering before death, which it sounds like there probably wasn't much, and funeral expenses and medical expenses, which are going to be less than $25,000 probably. So yeah, I would be careful about asserting both the survival claim and the wrongful death claim if it's not gonna help your clients.
Next slide, please. Okay, so there is a lot to talk about. Y'all's lien is limited to the reasonable and regular charges.
Yes.
Okay, can you tell me what the Supreme Court says that means?
They haven't told us what reasonable means. They've told us that regular means what you charge everybody for the same or similar services at the same time. So you can't have one set of charges for accident victims and a different set of charges for everybody else.
So the next few slides are going to be about reasonable and regular charges, because that's what the hospital is allowed to make you pay. And then the case law on this is kind of a little bit all over the place. From a practice standpoint, most lien holders, after they file the lien, you call them up and ask them for the amount of the lien, they're going to send you a bill that is the charge master rate. Can you tell us what the charge master rate is?
It's just the list price for each good or service. I think that some courts have referred to it as like the rack room rate. It's the unadjusted charge for the CT scan or the X-ray.
So it's the price on the menu.
Yes.
What our courts are struggling with is the idea that for the same services that you guys have assigned a value, a person on Medicare or Medicaid or CHIPS is going to pay one number. A party that has Blue Cross Blue Shield is going to pay a different number. And a party that wants to pay for their treatment in cash is going to pay an entirely different number. Is that fair?
Yes. My clients would hopefully tell you that the charge master rates reflect the fair value of their services, but they would also have to admit that just about nobody pays the full charge master rates these days.
And so almost all of the litigation on this topic, really starting with In re North Cyprus, starts with this principle of what is the reasonable and regular rate. That's what courts are mostly fighting about. Fair?
Yes.
Next slide. So this is a case that my firm handled, so I'll speak about this slide for just a minute. This is a case where we had a hospital, we didn't have enough funds to pay off all the liens. There was about a $75,000 hospital lien, and only $50,000 to pay everybody, including the client, and his attorneys. The interpleading hospital in that case took the position that the statute as written did not require the rates charged to be reasonable. So think about that. They're saying we can charge whatever we want. We don't have to defend our rate as reasonable. It just is what it is. And they happen to be charging the charge master rate. We argued that that was an incorrect interpretation of the law. The trial court went with us, the appellate court went with us. But we got some interesting language on that topic out of our appellate court. I don't remember if it was the first 14, but they added this language, which no one argued for. Plaintiffs didn't argue for it, defendants didn't defend it. This was, the court added this language sua sponte, and I'll read it to you. A hospital that does so charges an unreasonable rate is subject to disciplinary action, revocation, suspension, non-renewal of its license, in addition to other civil, administrative, or criminal penalties as provided by law. You won't find this language, so far as I know, in any other cited cases. And I can't really take credit for it because it wasn't my idea. It was the court's idea. But that might give you some sense of how the first and the 14th courts might be leaning on this topic. God knows what they would do at the Supreme Court. Nathan Heck might decide this is apostasy. But the point is, our local courts seem to have, from my perspective, a pretty good grasp on this and suggest that if you're not presenting a reasonable and regular rate, that you could be in pretty serious trouble. Interestingly enough, after we got this opinion, I countersued the interpleader alleging a fraudulent lien and cited to the statute. So if you're in a situation like that, remember this case, you might have a stick to use against a lien that you think is too high. Jared, cover your ears, you didn't hear anything. Okay, next slide. So what happens when there's not enough money to satisfy the liens? This is not really your problem. This is kind of my problem. So what I do in these cases, you chime in with whatever you think is a good idea or a bad idea. I make them an offer in writing, because if you sue them for filing a fraudulent lien, they're going to countersue you and they're going to ask for their fees and expenses. So I always make them an offer in writing that I can later present to the judge when they go to argue about their fees and expenses and say, look, judge, this is how reasonable I've been. This is how nuts the hospital's being, or the ER, or whoever else. I interplead the funds. You don't want to be in a situation where you've taken money and now they're fighting about whether or not your release is valid, and you've already given that money to somebody. If you know there's a hospital lien that's not satisfied that you're going to be fighting about, give that money to the court. We also got good law in the In re Pool case saying that is exactly what you should do. And if the other side says that you've taken the money or converted the money or committed fraud, which in this case, they didn't say I committed fraud, but they got real close. Our trial court judge said, look, you can't hold Mr. Herbert responsible for giving me the money, giving the court the money. That's exactly the point of the interpleader's law. 3, I send my petition and my pleading and all the notice I can to the lawyers or general counsel for the hospital. I say, welcome to the party. We're fighting about your money. Come get it, file an answer. I also move to disperse the funds. That's the first thing I file after I interplead them. Motion to distribute, motion to enforce, a motion to allocate, whatever you want to call it. And my argument is, judge, there's nothing in the statute that says my contractual attorney's fee lien is any smaller or any less significant than the hospital's lien to get paid for their treatment. I haven't yet gotten a judge to bite on that idea. But if you put that in front of them, boy, you will get a response from the hospital lickety split. And that maybe gives you a better chance to get your lien resolved. Finally, if they intervene, which they probably will, they won't just let you walk up with their money, get real serious about discovery. If you read In re North Cyprus or In re Pool or one of the other cases, the Supreme Court has actually been extremely specific about what you're allowed to ask for in discovery. And even those things that the Supreme Court has said you're entitled to, the hospital will never give you. And so as soon as you go in there on your motion to compel, hospital's gonna get real nervous and try and resolve that case. Because hospitals, and justifiably so, don't want to share with you the history of how they set their billing practices. For the big hospitals, it's proprietary. It's what gives them an advantage over other hospitals. It's their secret sauce. They will fight you tooth and nail, and your judge will probably say something like, well, if you're gonna prove up your lien to be reasonable, how are you gonna do that without telling people what the rates are? So those are kind of my 5 things that I would dive right into if you're in a fight with a hospital over the reasonableness and regularity of a lien.
Kyle, was pool, the hospital lien statute,
The old
applied in pool was before 2019.
Correct.
So after September 1st, 2019, the statute says that the hospital's best day is half your money. And your worst day is the hospital getting half your money. I would argue that the court doesn't have the discretion to award the hospital less than half your money because it says it right there in the statute. But Kyle would oppose that argument probably vociferously. You know, just remember their best day and your worst day is half the money.
If they don't start at half the money, they're being disingenuous about their responsibilities. Okay, next slide. Good point. Thanks for pointing that out. So we've already talked about this, but for the benefit of people watching at home, when the hospital is trying to prove up their lien, you're allowed discovery for Medicare rates, Medicaid rates, for private insurers. And so you can really narrowly tailor, like a laser beam, what your discovery in a lien fight will be, because there's 2 or 3 cases that tell you in minute detail what you're allowed to serve on them. Don't serve anything more, and certainly don't serve anything less. Okay, next slide.
But you can serve less if you want to.
Or you can just notice a corporate debt depot and have Mr. Johnson to your office.
No, you can't do that.
Some negotiation strategies that I run into: split the baby offers. If they're splitting the baby on a gigantic rate, on a master charge rate, don't enter into that discussion. You're going to start wrong with it. Also, 50% offers under the new law are not a reflection of reasonable rates. I believe we just discussed that. Jared just told you all the reasons behind law. Remember that production in these cases are very expensive for the hospitals. They're expensive to generate, expensive to get expert testimony, time consuming, and they are really nervous that the contractual rates will get out. So if you file that, they come to you with a compromise offer. Listen, we're going to give you some random calculation that we put into a black box, and that's the number. Don't agree to that. Make them give you a number based off the threat of extensive colonic discovery into their rates. Okay, next slide.
Yeah, I've got no comments on that.
Do not interplead the hospital before settlement. Any defendant or carrier has the exact same standing as you do to challenge the reasonable rates of the hospital. What you don't want to have happen is the lawyers defending your third-party lawsuit. And this is starting to happen a lot. Jared and I just had a case like this, where I represented the plaintiff, Jared represented one of the doctors, and we had to have this fight. Any lawyer from Allstate or State Farm or USAA or anybody else has the exact same standing to walk into court and say, I think those charges are nonsense. I don't think those charges should be submitted to the jury. I want to conduct discovery against the hospital. So you don't want to bring that hospital into that fight because it's going to tip off that defense lawyer that maybe they should start propounding discovery to Parkland and St. Luke's and Memorial Hermann and Christus St. Joseph's. And that is a time-consuming fight that will not help your case. It can only hurt you. So don't interplead them before the case. You agree with that?
Absolutely.
Next slide. So interpleader is pretty easy. You can look this up. This just gives you the basics of how to do it. We both dealt with this. I would treat it as deck action. I think you could bring it as a DTPA claim against the hospital, maybe as against a third-party lien filing. I have not done any case law saying that's good, but that's the way I would do it. Interestingly enough, claims under the CPRC for the fraudulent lien statute gives you 10,000 in damages plus your actuals plus court cost fees and exemplary damages. So wrap your mind around that as a plaintiff's attorney fighting against a lien holder. You've got, first of all, the statute was not designed to fight hospital liens. It's designed to fight fraudulent real property violations. But I think it applies. The point is, if you've got two lien filers, which happens a lot, and you've got two people in a car, that's $40,000 in damages that you've got to be awarded if you prove the lien filed was inaccurate or not fraudulent. Sorry, you're right. Thank you, Jerry. Fraudulent. I've got some arguments about what I think constitutes fraud in this context. Jared's going to tell you they're all nonsense. The point being, all of this can be used as leverage to try and get your underlying case resolved, which is what you want to do. You don't ever want to have to go to trial in an ETPA fraud case against a hospital. What you want to do is go in front of the judge and say, look, these doctors did good work, they saved my client's life, I want to make sure they get paid. Man, these numbers make it impossible for me to settle my case. So you can plead all this stuff, whether you win or not. The point is to put pressure on the other side to try and get it resolved as best you can. But by the way, this stuff comes up after you've been fighting about it for a good long time. So don't jump to this solution right away.
I'd agree with that.
Next slide. Discovery and experts. They take forever. Oh my gosh, they take forever. It makes things real expensive. You don't want to hire one. Hospital don't want to hire one. Hospital certainly doesn't want to use one of their own staff or vice president for managed care to come in and give that testimony. That's really not fun for them. Next slide. So this is the battle order for discovery. Ask first, ask often. Just because it's limited on paper doesn't mean you can't cross-examine their experts on it, and their experts on attorney's fees. That same discussion we were having earlier about when you tell the court what you were willing in writing to settle the case before, probably limits their attorney's fees arguments later on down the road. But the point on this slide is diligence. Just keep pushing. And if they are silly enough to designate an expert on the reasonableness and necessity of their fees, take 6 hours. Ask them a lot of questions. They're real squirrely. Next slide. So,
One more thing about that.
jump on.
Don't waste your time tilting at windmills trying to oppose the protective order. They're going to get it. All the cases about this say that the medical provider can get a protective order.
So that is 100% accurate. Read the protective order. Ask your opposing counsel if it's been entered in other courts, approved by other judges. If it has, and even if it hasn't, if it's even close to reasonable, just say, okay, sign in, ask the court to enter it. That is the holding of I believe In re North Cyprus has that issue come up. And they said, of course they're entitled to a confidentiality agreement. Agree to it. And then when your file's done, if you have that stuff, do the right thing and destroy it. Make sure it doesn't lay around. Make sure some paralegal doesn't grab it on accident and refer to it in another case. To be fair to the hospitals, these are their negotiation tactics, and they should be entitled to that confidentiality, and that's what our courts have held. Interestingly enough, in the Pool case, those attorneys said that they would produce records pursuant to a confidentiality agreement. I immediately agreed. They then objected to their own confidentiality agreement, which I then filed with the court and asked the court to enforce. And the Court of Appeals said, really? What are you guys doing? You asked for confidentiality. Mr. Kyle did the right thing and said, sounds good. The court then ordered your confidentiality agreement enforceable. And now you're saying it wasn't confidentiality enough? Now, if you went to the law school of Animal House, you know that's double secret probation. But the point is well taken. Just agree to the confidentiality. There's a lot of fights about it, and you're always going to lose. So hospital liens are kind of like poetry. Slide. Everyone hates it. You want to get your case done. You want to get your case resolved. Jared wants to get paid. I send checks out every week to Jared's office. Makes Jared happy. Sometimes he takes it out for lunch. Very often, he shows up to my office with ugly green Baylor color. The point is, to a certain extent, despite it's kind of a shell game, right? Hospitals don't want to tell you what they're really owed. You don't want to tell the defendants what you really think you're going to pay. You just got to take it step by step. Remember your responsibility to your clients, and try and work a deal as best you can. Is that the last slide? No, what's the last one? Yeah. So Jared and I can talk about this. We've only got a couple of minutes left. Bad cases and bad lawyers make bad law. I don't want to throw anybody under the bus, but the Supreme Court, if faced with a fight between Dallas Parkland, Memorial Hermann, St. Luke's, one of these gigantic hospitals, and paying a plaintiff's lawyer, you do not have to think particularly hard or long to figure out how that's going to come down. So all of this stuff is intended to procure for your client the best possible settlement as quickly as possible. And so if you find yourself in an appellate fight over a $12,000 bill, maybe call me. I can try and help you walk through what you're about to do to the practice of law in the state of Texas. Jared and I have talked about this a lot. It can be a difficult balance between striking a deal that's good for your client now and fighting this long fight to save yourself a few pennies. There's lots of good lawyers that do this. So I'll just throw this back to Jared for any final thoughts.
I thought you were going to say the Supreme Court's head might explode when they were trying to decide who to stick it to between hospitals and plaintiffs' lawyers. But a couple pieces of advice. One, safe keep the money until you've got the lien resolved.
And if it turns into a fight, interplead it.
Yeah. I mean, interpleading it keeps it safe. Don't disperse it. Don't pay your client and yourself and decide that, 25% of the lien is enough to hold back, or worse, get your client to sign some self-serving document that says, I will be responsible for the hospital lien and indemnify Kyle Herbert for, when the hospital sues him or something like that. That would be at the very least an ethical violation. Might be a breach of fiduciary duty if you were the trustee of those settlement funds or the constructive trustee of those settlement funds. But at the very least, it could get you in the hot water with the disciplinary committee. And it's the wrong thing to do. Don't start out the conversation with the lien holder in an adversarial fashion. Most of the good ones just want to get paid something fair for the services that they rendered. Most of the good ones understand that if their bill is $50,000 and the statute says they're entitled to 50% of the money, and you only got $30,000 and there's no UIM and there's no PIP and there's nothing else, the good ones won't say, well, the statute says I get 25,000, so you and the patient can fight over the remaining 5. I mean, that's when you would end up at the courthouse in the interpleader. Hopefully, they exercise more common sense than that. But you've got a dilemma when you've got a small pool of settlement funds and a lot of claims for medical providers, whether it be just lien holders or protected medical providers. And your client wants money and has unreasonable expectations for how they were gonna get rich and never have to work again a day in their life. And you'd like to get paid for putting up with that person, for getting them paid as much as.
That never happened with my office. All my clients are wonderful people. Honest, hardworking.
Yeah, but that's my advice, is don't take the position from the outset that medical providers shouldn't get paid and didn't do, their $40,000 bill is really worth $712. Cause that's just gonna turn out disastrously. But I guess that's my words of advice on hospital liens, not from the statute, just from 15 years of doing it.
So I would say in my cases, 95% of the liens get worked out by email or letters. And I don't, as an attorney, ever have to get involved because my lien reduction department handles that. I would suggest if you do get in a situation where you've got a small amount of money fighting over a large amount of liens, or even better, a large amount of money fighting over a huge amount of liens, and you have the lien filing with an attorney's name on it, or a law firm on it, call that lawyer up and quickly explain to them, probably in one email, this is all the money, this is all the debt, these are all the liens. We got to figure out a deal. That's usually the best approach. My biggest fights come with bill people who aren't lawyers, and that's when things get unreasonable. Sorry, was there a question from the peanut gallery?
Yes, 50% of the billed amount or gross settlement.
50% of the gross settlement
Yes, 50% of the gross settlement
is
that
the
the
max.
lien attaches to. If the lien doesn't attach to the UM, UIM, or the PIP, or the guest medical or the med pay, then it's 50% of the money that the lien attaches to, not that other stuff. And I may be the only guy in the state that doesn't think it's a settled question whether the hospital lien attaches to all UM, recoveries.
Your court is in the minority.
Yes.
Are there any other questions? We've got maybe 4 minutes to chat.
Is there a length of time that a hospital has to file a lien?
Only kind of. They have to file it before the money is paid. Or perhaps before you disperse the money to your client.
So they could file a lien after settlement, but before disbursement and still be a valid lien?
As against you, perhaps. All of the cases are about hospital lien holders and insurance companies fighting, except for Bashara, but he was just trying to get his fees over the hospital lien holder, not about the validity of the hospital lien. But yeah, I had a case where we filed the lien 30 minutes before the auto insurance issued their check. And the Court of Appeals said that was before money was paid. The lien is timely.
I was actually gonna ask that exact same question that Andy asked, but in a different way, in a different way than you answered. I've had liens pop up after, and I know they can go pound sand on, if it comes up after my thing. What about the money sitting in my trust account? Cause sometimes you'll get an insurance company that calls and says, I know you guys fucked up. I know that they're in the hospital. We have a 30 policy. She can check right now. And we deposit it. And suppose after it's deposited, before we paid out, the lien's filed.
Well, the lien certainly isn't good against the insurance company if you've negotiated their check and put it in your trust account. The lien might be good against you because you haven't paid the money to the injured individual before the lien was filed. But certainly if he's come in and signed the disbursement agreement and gotten his check and cashed it before the lien is filed, then it wasn't timely. But the lien might be good as against you, your firm, if it's still sitting in your trust account. But that's not a settled question by any means.
I would say in my office, the hospital liens are filed as a matter of course. It's rare that we don't see one. In fact, it's so rare that I'll usually take notice of it. We've had a couple of rural hospitals who just don't know how they don't file a lien. I kind of make it a point to add that to my kind of checklist to close out a file. And we'll pull up the county record just to make sure that before I disperse funds, that there still is nothing filed. It's never happened. I did have a hospital in Allen, Texas once, like filed a lien 2 years after the case had been settled and after the wreck, and after we had called them to try to pay them. And then they got my client had a lien notice, and I said, well, I'm happy to write a letter for you, but the answer is that opportunity is long gone. The hospital's not in good shape.
Yeah, it definitely has to be paid, or sorry, filed before the injured individual gets the money. Once the injured individual has the money, then the hospital lien is too late. And Romo, if you're arguing that, that's what you're gonna say is, I don't have this money. This is
I'm not
my
arguing
client's
that.
money. We have, when it's in my trust account, it's my client trust account. It's his money when it sits in my trust account. So, that's your argument, though you may have a fiduciary duty to people with claims against the funds in your trust account. So be careful, but
I unfortunately have never had that one yet, but we missed it by a day or two one other time.
Yeah.
We paid the client out and somebody else security.
Any other questions? So I'll make sure that you get Jared's contact information. So if you got any brain busters, you can reach out to him. But Jared, thanks for your time, man.
thanks for having me.
Great. We've got food and cocktails. If anybody wants to come upstairs to the 4th floor, we'd love to have you join us and chat with Jared or me if you have any other questions. If not, we will be doing 2 more CLEs. First week in November, one the first week of December, and then I'm not going to be doing one the day after New Year's Eve. So we'll pick back up in February. All right, thanks everybody for coming. Appreciate it.